If I may introduce Brendan Fleming. Where are you sitting in hiding away? There we go. Mr. Fleming is a family law solicitor. So I know there's going to be a lot of questions, so you can save us for the end. Thank you.
So, first of all, let me assure you, particularly this gentleman, I never ever represent local authorities. Never. Can you hear me again? My name's Brendan Fleming, and I'm a solicitor looking after parents in care proceedings. We never represent local authorities. And if you do need a solicitor locally for a care case, never have a solicitor who's also worked or currently works for a local authority. It's quite simple. You don't go to court one day with a barrister to defend you against the police, and the same barrister in the same day or the next day is representing the police. Because the next day he's having all these cosy conversations with the police, isn't he, to get details about there, and they'll say, oh, don't tell him about I've not done this or don't do that. At the end of the day, it's horses for courses. You've got to have a solicitor every time who has no connection whatsoever with the local authority. That's quite difficult in some areas because some areas are quite small. And the local authorities love instructing local solicitors. The pay is really good for the solicitor, 3 times what you can earn on legal aid. But the most important is that's one less who's going to challenge them effectively in the local courts. Now, I came into care law about 20 years ago when the new Children Act came into force, because prior to that I did do care proceedings, but it was done completely different. I want to just give a bit of a history lesson. I was born in Ireland. My parents came over in the 50s for work. My dad worked in a factory. I was brought up on Perry Mason on the telly, and I always wanted to be a lawyer. And in those days, if Laurie remember, if you wanted a job, all you did is walk around the streets, and on the outside of everywhere you went, there was a job. It was either a crisp factory or a factory or an office or a bank. Just walk inside and get a job. I walked into a firm of solicitors and got a job at 17. I've never looked back ever since. And I was doing crime. I was put in the criminal department. It was my job to go to the venue where a crime had been committed and work out how we're going to get our client off. It might be a cemetery, it might be a supermarket, it might be a football pitch. And that's how I was brought up. And in those days, as solicitors, they were really good solicitors. They fought for their clients so tenaciously, and by God, did they have opposition to fight. They had the West Midlands Serious Crime Squad, and you'd suddenly lose your client for 3 days and he'd turn up at your office covered in bruises. And those solicitors had a hard job to do, because also what the police had already was a statement signed by your client admitting to the offence, which they hadn't actually done. And that's where I cut my teeth in these sort of cases. I've also done cases in Thailand, in drug cases, and I've done all those sort of cases. And then one day, in my offices, one of the lads says, I've had enough, I'm just going to retire. And he did the odd care case that we used to have it brought into the firm, which usually I did at court. And do you know how it used to work in those days? Basically, what used to happen was, we'd go to court about 15 criminal cases, and one of them would be, child cruelty. 1936 Act. You remember that, you know? Child cruelty. Oh, that's a doddle, isn't it? If I win this, it's okay. If I lose it, the mother might lose her child. Well, probably I'll be able to charm the magistrate into giving her a conditional discharge, and she can walk out of court with the baby. And that's how it used to work, and we used to have about one of those every month. Come the Children Act, I was told by my colleague, listen, you can get out of all this being in police stations for 3 to 4 days at a time, all these murders and rapes that you do, all this hassle, you can't even drive your car down the road without being stopped by the police. You have none of that. This is going to be so easy. The social workers are so nice to the clients. If they've got a dirty house, they'll go and help clean the house. If they've got a bit of drugs or a bit of this, they'll ignore all that. It's only the serious cases, Brendan, where there's going to be, you've got to fight and get stuck in there and make yourself unpopular. And it used to be like that. It really was like that at the very beginning. And then it all changed gradually over the years. And over the past 5 to 7 years, it's gone mad. What I want to try and help everybody today now is give you some idea how you can stop a child being adopted, okay, legally through the court process. The first thing is this. You've got to really realise and identify those cases where adoption, as far as everybody's concerned, the courts and everything, it's written on across the file from day one. And those are the ones which you've got to take special measures about. Obviously, they're going to be the ones where you've lost previous children to the local authority, and perhaps very recently, if you've lost a child last year to the local authority, and you've just given birth to another one, you know they're coming for you at the hospital. They're going to take this child from you at the hospital. Every time. So, whatever bullshit you're given, that is what is going to happen. So you've got to get ready. You've actually got 9 months. From when you know you've got the baby, and you go, as soon as you walk into the midwife, that's when the clock starts ticking, because she will pick the phone up and tell social services. She's got to. They will then call an unborn baby conference. That's your opportunity of getting yourself a solicitor. The solicitor can do up to 2 hours of work, and most solicitors will do as much as it takes, and go along with you to that conference. That's your chance then to try and get them to see that you have changed. Bring people with you to the conference. Your mum, your dad, your sister, your uncle, your best friend. Put them forward as alternative carers. You've got to have plan B. They say they will work with you. They will not work with you. They're already making their mind up how to pacify you between now and the hearing to get the child. You've got to start making changes yourself. If you've got drugs, you've got to go and get help. If you've got a risky boyfriend who's never going to pass an assessment in a month of Sundays, you've got to finish with him. You've got to finish with him. Because you're going to lose your child. Do things, get your solicitor to write out a list of things you've got to do, but do not rely on the social workers doing these. If you've got rent arrears, don't ask the social worker to help you. Right? Do it yourself. Go to the right places. You've got that period of time before it gets to court.
Excuse me, sir. We're talking some monsters here.
Sorry?
We're talking about monsters, aren't we?
Yes.
Thank you.
What you've got to do is work with your solicitor and work with other organisations. Don't rely upon the social workers doing any of this for you whatsoever. They've got their own agenda. When it gets to court, and often in my firm's case, what happens is we get a phone call the night before. Normally, social workers will issue proceedings on a Friday afternoon, and you're going to be in court on a Monday. Because obviously the social workers don't work the weekend, neither do the court. So we remember the quiet life I was going to have when I had my weekends to myself and I wasn't in police stations anymore and I could go home at 5 o'clock? Well, that's all gone. Because we are tackling these cases in exactly the same way as if it was a criminal case, right? And what our offices are open all day Saturday, all day Sunday, and we're quite busy. We're preparing cases that we only knew about Friday afternoon. The biggest problem with the care cases is that you need to fight on the first hearing. You need to oppose the interim care order. You need to oppose the emergency protection order. Now, the emergency protection order will only last for 8 days. As solicitors in the family law, we have great success on getting emergency protection orders chucked out. Because what they do it on a Friday afternoon. They think you want to go home at 4, and we're quite willing and have done to stand there till midnight on Friday and get it adjourned to Saturday starting at 10 and running it the whole of Saturday. And that puts them off. But you have quite a good rate of success on an emergency protection order, okay, because the standard is very, very high. With an interim care order, do not agree to an interim care order at the first hearing on the basis that you're going to cooperate with social services, they're going to see you all right, and it's all going to work out. You do not do that. You need to fight. That is exactly that scenario of, we'll agree an ICO, we'll work with you, and you'll have your child back. That's exactly what I used to go into police stations when I was in my 20s. Officer, how are we doing? for a packet of cigarettes and for bail, and if he signs the statement, don't worry, when he gets to court, we'll turn up and we'll put a good word in with the judge and you'll be all right. It's exactly the same scenario. You give us what we want, and then later on we'll think of a way of getting out of it.
Can I just say so? The thing is, when you go through this, you don't know it. We're all here because it's happened to us. So it's, you know, if I knew what I knew now...
A good point, because my clients...
didn't even tell me the law properly.
My criminal clients used to get together in the pub and give each other tips about what they could do when they got arrested by the old bill and what you could do here. You're not allowed to do that, are you? You're not allowed to talk about cases.
We do talk about it. You just don't know.
Yeah.
You think social services, when they say they're going to return your child, you believe them.
Yeah.
Then they call you angry in press. Of course you're going to be angry. And when I've actually got my files, which have taken months and I haven't given them all to me the other day, I'm reading through it. The first thing the case said to them, are these children up for adoption?
Right, okay.
You know?
Can I just carry on with the section 20? You know about section 20s, whereby you signed to put your child into care. It used to be called voluntary care. Again, you mustn't sign the section 20.
Yeah. Mark said tell me to sign it.
Okay, right. You must sign the section 20 because you're giving them the care without having to get through the court and prove the case. Okay? That's like signing that you committed an offence, which you haven't, so the police don't have to investigate it and don't really have to do any work because they've got you signed up to it. Now, moving on from there, at the first hearing, even if you think you're not going to get your child back, it's very important to fight the interim care order because you're going to test the local authority's evidence, which a lot of it is rubbish. A lot of it is rubbish. And if you get rid of that rubbish out of the way, by getting the magistrate or the judge to say, well, I don't find that, that's not part of this case, that's not part of it. Now, you've got your things you've got to concentrate on, which are the problems why you can't have your child back. But also, by fighting at the first hearing, like we did the other day, just last week in Coventry, we got the judge to agree that while the mother couldn't go back to the house, we got her into a residential unit in Coventry. So there's lots of options that you've got at court, and you just want to see their faces when you say, we're going to fight this case. Suddenly they come out with more contact. How about a residential unit? How about this? That's the first thing. You've got to fight the ICO. The ICO initially will be made for 8 weeks. And don't think that that's the end of it, because when you can say to the court, that's okay, fix another hearing in 8 weeks, please, and another full day, because we're going to fight it again. Because by then, we'll have fresh evidence, you'll find that it isn't quite right what you say about our clients, and we'll be able to call more witnesses, etc. You've got to fight the process all the way through. Obviously, there comes a point where you can't keep opposing ICOs because you've run out of your fresh evidence. Now, during this period, now that you know that your child is in care, you now know the shopping list that you've got to deal with because the magistrate or the judge has dispensed with a lot of other things. Now we get into the different situation, because what the social workers will do now is move the goalposts. If they took the child away from you because they thought you're an alcoholic and they now find out you're not an alcoholic, then they'll do an assessment on you and find other things wrong with you now. Now you're having splits, okay, you're falling out with neighbours. They've got reports from the police that you and your partner are arguing all the time, therefore the children are witnessing. So now you've got to deal with all these new issues. But you've got to deal with these issues. And understand it is not a level playing field. As solicitors, we're doing these cases on legal aid. We are on a fixed fee to do these cases, and more we're told to do them quicker, cut out corners, and so forth. If you have now got to start working at this list, you've got to effect the changes that they say that you need to effect. Also, try and choose a solicitor who has got the background in doing criminal work. Because these cases now, they need to be fought out as if they are a criminal case. We are in the family courts, but it does need somebody who's got the ability, the willingness and the bottle to cross-examine social workers. When they put a statement in, we don't just accept that. I want to see your notes. I want to see your notebook officer. That's what I want to see. I want to see, did you make your notebook up with another officer? So an officer who can't even spell bloody Birmingham or Erdington, and that spelling mistake goes into the other officer's notebook, That's what we're looking for, to try and discredit the social worker and to try and prove at the end of the day that we can get this child back for you. You need to be forensically...
Most people are given a list from their social workers and told their solicitors they're what to use.
Yeah, don't use anybody on the list. Okay, no. Would you, again, sir, if you got arrested for a criminal offence, you got took to the police station, the police officer says, I'm going to knock the shit out of you, would you then have a solicitor with a list he gives you? No, would you?
No,
you would not.
You've got a young woman that don't know what they're doing.
Right. I appreciate
You're innocent people. You're innocent.
I know you are. And that's why, you know, there are these lists going around. I don't think, I'm pretty sure I'm not on the list in Birmingham. In fact, the list is so outdated, it's got firms that do just bloody conveyancing. They don't even do family law. They've certainly got one of my friends on there who died 5 years ago, right? So, you know, you've got to think here, look, you know, I'm going to be facing a court case for losing my child. So I'm going to ask people in the know. There's plenty of people in this room who know solicitors who can look after you. But try and get somebody older like me, right? Old like me, who's been around a long time, around the block many times, who's done criminal work in the past, because you're going to need somebody good in court. Because what you don't want your solicitor to do is send endless different barristers to the hearings who really don't know a lot about your case and are only there for the day.
What about the children in this country who are allocated lawyers from the courts?
Yes.
The most corrupt lawyers going. And every child who has those lawyers have, it doesn't matter about the parents having good lawyers, those kids in there have the corruption of those lawyers.
Right. The solicitor for the child...
the kid has no rights.
Let me explain what the system is, okay? At one time, till quite recently, the solicitor for the child was appointed by the court, and it was on a rota system. Basically, we would get a phone call, can you represent this child? Usually we can't, because nearly always in Birmingham, we've always got the parents on board. Okay, and of course we're not allowed to operate for children outside Birmingham because we're not on the rota. This changed recently, in about the last 12 months, whereby what happens now is that the guardian gets appointed first. Yes, the guardian is appointed first of CAFCAS, and now it's the guardian who decides who that guardian wants as her solicitor. Right? That's how it works now. You can imagine I don't get many guardians asking for me to represent them compared to what we do to them in court. We've got very few children work, haven't we, Sophie? Very few children work indeed, because we turn over the guardians in court and they don't want to know us, basically, right?
Yeah, but they don't speak for the children.
Sorry?
They don't represent those kids.
Well, that's another subject, right? Well, I'm trying to help you to...
Can I just say, I know how strongly you all feel and what you've been through, but Brenton is here, charting a path. We have to find a way that we can publicise what he's saying so that we can help people before it happens. So give him a hearing, you'll get a chance to say how you feel. That's why we're here today. But let him tell us
lynch
what
me
he
later,
has to
just
say.
here at the moment. Right. Now, you've got that period between then and the final hearing, and this final hearing used to be quite a long time at one time, up to about a year ago. You usually got about a year, we'd say to our client, to knock your drugs on the head, get yourself sorted out, get yourself decent accommodation. How long is it now, everybody? What is it now since April you have got? How long have we got now? 26 weeks since April this year. 26 weeks the court's given us now, and they're telling us that's the date that this case is going to be finished, okay? So it's a much shorter time for us. So whereas, for example, the mother I've just spoke about when it's a residential unit, she'd be there for 3 months. Say she failed in the unit, we would challenge that and then try and get an independent social workers report to try and reverse the damage that has been caused in the residential unit. That's what we would do. We're not going to be able to do that now because the judge is going to say no more assessments, the clock's ticking, we've got to get the case sorted out. So therefore you end up now, also the most important thing where some parents do let themselves down is that you must go for every contact. Obviously, they're going to make it difficult. If they know that you're doing drugs, they're going to make it 9 in the morning, because you have difficulty getting up in the morning. They're going to place your child, say, next town, and say you can get there by public transport, 3 buses, two planes and 1 train, right? But you've got to do that. But that's where your solicitor and court skillfully can renegotiate the arrangements to make it easier for you to get there. Don't leave court at the first hearing with just a promise that contact's going to take place. You need to know the nuts and bolts of it, so if necessary you can argue back that in court, that once, twice, 3 times a week is not enough, we want 5 times, we want it reasonable times, etc., etc. Come to the final hearing, a lot of people throw the towel in. A lot of people go to the final hearing and they've had enough and they just throw the towel in. Now by doing that, by consenting to the final care order, and we're talking here about adoption rights, so we're talking about a placement order. When you consent to an order at court, you can't appeal it. It's consent, you can't appeal it. So you need to go down fighting. You still need to go ahead with your hearing. No matter what your barrister tells you, at the end of the day, if you feel you want to have a day in court, you have a day in court. And I'll tell you what, when I was doing criminal cases particularly, and they looked absolutely hopeless, and the client still wanted to fight them, I'd have to come out and apologise, because I would win a lot of those hopeless cases for the client, and they were right to fight that case. And it's the same with care. We have one care case where we thought they were hopeless, but we have still won them. You don't know what's going to happen in court. Up to that point, it's all written statements. The local authority's case looks great, yours looks hopeless. But when you start digging deep, then of course the cracks appear, and then you can make some good headway with some of these cases, and perhaps get adjourned for further assessment, for example. Now, if the case goes against the mother or father in court, and the court makes a final placement order, is that the end of the case? Most people think it is, okay? It's not the end of the case by any means whatsoever. Normally, what will happen then is the solicitor will say goodbye to the client because the legal aid certificate is finished and the case is over, and that's the end of it. These are the options that you've got. Now, this is really, really important that I'm telling you now, because a lot of this is not done by other solicitors. Number one, you have got the opportunity of going away, sorting your life out, persuading your mum to come forward at long last to be a kinship carer perhaps, or your auntie or somebody who they didn't quite realise the seriousness of it before. You've got the option of going back to court in 6 months' time. And what you do is you apply to the court to revoke the placement order and discharge the care order. If there's been no placement order, you just apply to discharge the care order. And you go back on a change of circumstances. I used to do drugs, I don't do drugs now. I used to do this, I don't do that. I've improved my situation. I remember a case last year where there was a final placement order and my client would never leave her husband, never leave him, and he was violent. He died. She came back to me and we said, okay, let's do what we can then. Come back and see me next week, go to the funeral, come back next week. She'd been to the funeral, she brought a horde of people into my office on that Saturday. They'd come in from Italy, these people. They didn't even know that her child was in care. She hadn't had the... So humiliated she hadn't told them. They came forward as kinship carers, we revoked the placement order, that child's gone off to Italy now to live with those people. So after 6 months, you've got the opportunity going back to the court on a change of circumstances to discharge the care order. And you know what? You can do that nearly every 6 months. You can't do it for less than 6 months. So normally what we will do, we'll normally leave it for 6 to 8 months, call the client in, how you doing? If you're still where you were before, there's nothing we can do. If you've improved your situation, let's get funding for you. I will certify legal aid for you if you've got a good case. Take it back to court and reopen it and get your new assessment. Right? We hope by then, of course, they haven't placed your child. Probably not after 6 months. That's the first thing you can do at any time, and at any care order, you can apply to discharge the care order. And for example, if you had an auntie, then they might give her a residence order and discharge the care order. So a change of circumstances. Next, you can revoke, as I say, the placement order on the basis that there's been a change in circumstances. So where there's a placement order, same thing again, you go back to the court, you ask them to set aside the placement order. Now, while you're doing that, normally the local authority will give an undertaking not to place your child, to give you the fair right of having the case reopened. Next thing that you can do, which is what we've been doing recently, this is something new that we've been doing with the people, in fact, who are here today. We've been going back to the basis for making the care order is the threshold, okay? And if it's non-accidental injury, and we've not then, at that time, or in this case our predecessor solicitors, have not been able to crack the medical underlying condition for a child, we have been doing a lot of research. We've got specialists in our firm every day, every night, looking for medical problems in children. We are now going back to the courts and saying, well, leave the placement order there for a minute, leave the care order, let's get to the bottom of why you made those orders. The only reason you made those orders is because of the fact-finding for non-accidental injury. We've got a new idea why you might be wrong when you found our client liable of non-accidentally injuring that child. Right, we've got this medical, our current flavour at the moment is vitamin D, rickets, etc. Following the death of Jade and Ray, when all the radiologists couldn't see rickets at all. So we mount an application to the judge to reopen the fact-finding. In this particular case, the judge listened patiently, I did the hearing, and then what they do, they send the big guns in, don't they? Okay, they send the bombers in then, and they send the QC in, and the QC for this, QC for that, and we're doing the case for nothing for the parents to help them out. We didn't succeed then, so we appealed it to the Court of Appeal. Yeah? They sent the QCs in again. We haven't succeeded at this point in time, but by God, are we giving it a bloody good run at the moment, right? And we're not finished yet with them. But in other cases, we had a case in Derby just last week where we've come up with a new explanation why these parents might have been found guilty and they weren't guilty. And the judge has said to us, you come back any time that you get something new and I'll reopen the case for you. So that's what we call a review of the fact-finding hearing.
Sorry, I've got to interrupt. Which judge was that in Derby?
Judge Arnold.
You are kidding.
No.
Sorry.
I've got a witness. Yes?
No, I don't doubt you. It's just...
Yeah.
It's
just.
just
Judge Arnold normally hears a fact-finding 1 hour, 2 hours, right? So when we picked this case up,
sorry,
this fact-finding was listed for
sorry.
2 hours. 2 hours, right? Okay.
Sorry,
We told him that was completely wrong. And he says, we don't do things like that, like you do in Birmingham, Brandon. He says, that's how we do it round here, right? Anyway, in the end, he had to give in to us, right? And we had a fact-finding for 3 days at the end, okay? And we weren't successful, but now we found some new medical evidence. He's fascinated. And last week he says, yeah, I'll reopen it if you can come up with the goods. And we're having members of the family tested for this rare disease at the moment. And if that is right, then we're going to get that set aside. So you can review the fact-finding. You can revoke the placement order. You can discharge the care order. Now, the next thing that you can do is this. If your child has not actually been placed, and there are thousands of children not actually being placed, as you probably know, okay, right across the country, and some children are more difficult to place than others, you can go back to the court and ask them to revoke the placement order because the child has not been placed. In other words, the court's plan for adoption has fallen apart because no one wants the baby. They can't find anyone to have your child. Now, and when you get back to court, on 2 cases we've done in Birmingham recently, what we then managed to persuade the local authorities to do, they had no option really, because don't forget, we don't persuade them to do anything really. They have changed the plan now to long-term fostering. We've got the contact for the client, and now my client, one good one particularly, can work on trying to get her child back. But we've saved the child from being adopted into a new family. Now, the last chance saloon, of course, is when they do find somebody, they do place the child with somebody, and then the adopters apply to the county court for adoption. Under the old system, the freeing orders system, you never had an opportunity to go into court. You were never told that was it. Once they made a freeing order, That was like an adoption order really, with no named person. Now, with the placement orders, it only allows them to place the child, and you still have your parental responsibility, incidentally. So they must keep you informed. But do they help? You've got to find out yourself. Okay? So basically, when somebody wants to adopt a child, they have to make an application to the court for adoption, and you now, under the new legislation, Section 47, you have the right to oppose that adoption. And if you can show a change of circumstances, and the recent case says it doesn't have to be like a really big change of circumstances, after all, you don't have to be perfect parents in the law, you've got to be good enough, then you have a right then to have that reopened and looked at again, your case looked at again. But there is a catch to this which we can't get around at the moment. We have actually persuaded, I've persuaded the judge twice recently to say, your client has changed. I accept that. You've got a report here, she no longer does drugs, she's with a fine fella, good accommodation. The next part of the test is the welfare test. And this is where you are stuffed. That's a legal phrase, incidentally. Because if the very nature of the case that you are facing is that your child is living with somebody else. And you know, when somebody wants to adopt a child, they don't say, oh, we've had the child 48 hours, just what we wanted, exactly what we wanted, and we go straight to court. They will have that child, perhaps in some cases, for up to a year, 2 years or something like that. And that child becomes part of their family, their brothers and sisters, they've been on holiday, all that, they've bonded. So the welfare checklist is the one that's going to get you, because the judge will say, hold on, how can I take this child away from this family now? Well, you did it the first time, didn't you? You did it the first time. I told the judge that the other day. He says, oh yeah, all right, well, fair enough then. But, you know, how can we now take this child away from these people? Too little, too late, Mr. Fleming, for your client. So that's the problem with leaving it to when they find an adoptive parent. However, for the first time in my life, a fellow walked into my offices the other day, and he's a Liverpool case, and he brought one of these in. I was just about to say about the welfare checklist, and I looked at the order, and it says this: the applicant, and these are proposed adopters, shall file their medical records, shall file, and the father, or sorry, the male applicant will file a report from a psychiatrist as to his abuse of alcohol. I'm thinking, how the hell did he ever get to the stage of being an adopted, just abusing alcohol? But now that has left that wide open for my client now, because his circumstances are such that he wasn't even involved in the original case. They couldn't find him. So now I can get him a new assessment, and I've got a much better level playing field there. Now I've got him who's a good one, and the adopter who's got issues with alcohol. So finally, let's just review. First of all, the only time that you're ahead of the game with the local authorities that you know you're pregnant, or your partner's pregnant. So you can plan before they know about what's happening. Then you've got the period of when you're having the baby, to build up a better picture of yourself. Most important, don't let social services do it all for you. You do it yourself, right? Then when the child is born, make sure you fight the ICO. Even the most hopeless case, you can move mountain on that first hearing, because they don't want you to fight it at all. Okay? You'll have the sympathy of the court, generally speaking, as well, that you're losing your child. You can go into a residential unit. Fight throughout the case and effect changes as you go along. Work with your solicitor, keep all contacts, etc. I know it's not easy to effect the changes. If the case then goes against, and select a really good solicitor who's prepared to go to court himself and fight the case, and has got a good background in forensic examination and stuff. If it's a non-accidental injury, that's a different situation. What you've got to do at the first hearing is forget about non-accidental, you've got to get that child to a family member. Grandparents are brilliant. We did one in Leicester today, we brought all the grandparents, we brought the whole family basically, and we got that child placed with one set of grandparents. Once you've got that child with the grandparents, that child ain't going to get adopted at all. Once you get that child with kinship from day one, normally speaking, that child will not be adopted. Then effect the changes, go to court and fight it. Don't give in. Do not give in at the court. It's the worst place to give in. Don't give in. I've mentioned, of course, the review, the discharge, the revocation, and of course, you would think the most effective way of getting something put right is an appeal. But I've left that to the end because that's a joke. Because you appeal, this is difficult for me to explain this to you. The judge won't say, oh, the judge below made a mistake, so therefore that's grounds for appeal. Making a mistake is not grounds for appeal. Basically, the judge has to look at the situation is that another judge heard the case, unless he was completely out of his mind when he made the decision, he's going to let that judgment stand. Okay? And you know, we used to have that problem all the time in the criminal courts. When the West Midlands police used to beat up the clients, and we want to tell the judge about it, and that's how we signed the statement, we always had the problem. If we told the judge about that and cross-examined the police officer in the witness box that you beat my client up, then when my client went in the witness box, all his criminal record would come out. Because if you accuse the police officer of impropriety, your client's criminal record used to come out, and then you used to get convicted. So the same situation that happens now. So you've got to be very careful what you do with appeals. At the end of the day, the Court of Appeal, they will only allow you to appeal something if it's patently wrong. And they're not going... And when it comes to credibility, where you have not been believed as opposed to somebody else in the case, then they're going to say, well, the trial judge heard it all. And that's basically what used to happen in the old days of the criminal appeals, and that's why there was still so many people locked up in prison who were innocent. And then what they did there, of course, is they formulated a board for miscarriages of justice. And then they were independently investigated and sent back to the Court of Appeal. That's something we probably do need now in the family courts, is some independent body that will look at some of these miscarriages of justice on behalf of the parents, and then, of course, refer them to the court. And then you've got the very credible situation of, it's not me saying I'm innocent, it's this independent board that can be referred to the Court of Appeal. And then finally, like we've done recently on the cases, you've got the European Court of Human Rights, which we have lodged a case on fact-finding, because we passionately believe that the present system of fact-finding and the standard of proof is wrong. Up until about 5 years ago, it used to be that the more serious the allegation, the higher the standard of proof required in the family courts. Okay? So in other words, if it was sexual abuse, you'd have in the family courts, there had to be a criminal standard of proof. Well, that was abolished by a case. And now it's all the balance of probabilities, which, as you know, is just 51%. And it isn't very satisfactory. Well, it's totally wrong when you're deciding somebody's whole life, and how it's affecting your child as well. And also in the criminal courts, when I used to operate the criminal courts, we used to choose the experts. Some of my solicitors who are long gone and dead now, the criminal lawyers, they turn their grave if I said to them that what you've got to do is you've got to talk to the police and see which expert the police want first, right? And then you've got to agree it all and go off to somebody. Because we used to choose our own experts in the criminal courts, and that still is the position. And as you know, in non-accidental injury, where a parent presents a child at the hospital, we've got an epidemic of these at the moment, up and down the country, good parents go to the hospital with a child worried about meningitis, worried about a mark, a bruise, anything. They leave the hospital in handcuffs, social workers take the child off them, they're on bail for 6 months, but we know they're not going to get charged. Okay? Then the family court takes over and deals with the case. We like those cases where they actually get prosecuted, because they do them a big favour. Because when they prosecute them and take them to the Crown Court, they're defence lawyers, okay? They get the experts they want. They prove the underlying medical condition for us. And then when it goes back to the family court, we get that lot, sweep it up, put it to the family court, and get their kid back, basically. Yeah? Sorry? If you're not prosecuted, well, and I've hardly had any parents prosecuted recently. Yet every day of the week we're getting people arrested and on bail for ages. If you're not prosecuted, then you're going to have a hearing in the family court which is slanted against you, because you can't really have the expert you want. In January, for example, they're cutting back, the Legal Service Commission and the courts family courts are cutting back on experts. You're saddled with an expert which is by consensus, parents, guardian, local authority, okay, and they're gagged, basically, as well, as you know. The standard of proof is 51%. And if you're in the criminal court, it's open to the public. So somebody might have that disease somebody might have that bloody disease that we're trying to prove in court, with all the symptoms, sitting at home watching the telly, watching your case in the criminal court, and phone the court, say, hey, I got that. And people can, the idea of having a trial in public is that people can come forward and assist you, and your lawyer can tell people, I need a witness to this person, I need a witness to this event, please. Can you come forward and assist in your inquiries? In the family courts, you could actually have a case in Birmingham, and a case in Coventry, and a case in Derby, 3 identical cases going on about the same subject, and the same witnesses popping in, one radiologist popping in there. No one's tying these 3 cases up, that there's common factors in them, same sort of fracture, same sort of this, same sort of that. No one is tying them up at all. But they would be tied up if they were in public, because they'd be in the local newspaper. And the barrister or the solicitor would be able to say, hey, that's just like my case. So yes, we have taken the case now to European Court of Human Rights, the one that we had in February, whereby we feel that the fact-finding process is not doing a service to anybody. It's not doing a service to the judges who are trying to grapple with difficult medical issues. We're not medical people, but actually we probably know more about medics now than most students. It's definitely not doing a service to parents. Absolutely not. And it's not doing a service at the end of the day to the child, because the child is going the wrong place. The child should be with the parents if they're innocent. They should not be with the parents if they're guilty. But at the end of the day, all we can do as solicitors is fight the system within the courts. And we've got one hand tied behind that. Particularly my firm now. My firm is really marked now out for special attention by local authorities up and down the country. We took these people's appeal from Sheffield to the Court of Appeal last June, and just when I said we're appealing, I get a letter in the post from the local authority, we're going to claim costs against you personally, Mr. Fleming. And then the Guardian, true. Then I got a letter from the Guardian solicitor, who I thought would have actually, if I was representing the child for the solicitor, I'd be delighted, thinking, let's look into this further. Because, I don't want to sleep at night if this child's in the wrong place. But now what do to me? They get a QC and they write me a letter saying, you're going to pay the costs. What, for appealing? Yes. Right, and he went to the Court of Appeal, and I had the backbone to take it all the way. We didn't succeed, so then they really had to go at me. £75,000 they wanted me to pay. But anyway, the judges decided that that's not going to happen. But at the end of the day, I'm marked on those particular cases just for appealing, which I think is what saved my bacon at the end of the day, because they were trying to get me to pay costs just for appealing. They hadn't even heard the case yet. They hadn't even heard the case they wanted me to pay, because obviously they don't want solicitors who are going to appeal these cases. Because I'll tell you, if we had won that case, it would have advanced that particular type of vitamin D situation tremendously. It would have led to a lot of other cases being opened up. So finally, when my mate said to me, yeah, there's a nice quiet area of work for you to do now, Brandon. You've been fighting these drug cases in Thailand, you've been going to these prisons and murders and all that, and these horrible police officers keep picking you up all the time in your car and doing this to you. And I'm thinking, I'm in the same position as I am exactly now. I've got local authorities who hate me. I've got people coming in on miscarriages of justice. I've got people who are bruised emotionally from losing their children. Nothing has changed except that I seem to be now, and you are, everybody in this room with your children, you're exactly the sort of clients I used to have years ago who were the subject of miscarriages of justice in the criminal justice system. Exactly the same thing. And I just want you all to fight for your rights and do something about it, like we did in the criminal justice system. For example, people went to the police station. You never knew which police station they were in. Nobody would tell you. Introduction of an independent custody sergeant. Proper records kept. Proper process for appealing. A miscarriage of justice board. Tape recordings of in a police. Wouldn't you like to be tape recording when you go to the social work? It'd be great, wouldn't it? So that at the end of the day, whatever they told you can be played back and used in court. So there's no disagreement what happened on your assessment. Yeah.
Couldn't they actually say, couldn't there be a law false that when you're on contact, and any meeting you have with a social worker, it is taped?
Yeah. Well, that's
CCTV, because the stuff they come out with is absolutely.
Well, that's what happens. That's what happens in the police station,
yeah,
doesn't
exactly.
it? Yeah. It's like if it's a serious case, like numbers and stuff like that, it will be video recorded. Okay.
That's what it should be. That's how I think
and
we're
if
going to fight this.
normal stuff, there would never be a police interview now without a tape. The reason for that is people used to say the police would verbal them, and that all had to go. Yeah. So
how long can the police keep somebody on police bail without charging them? Because
very good question. We did a case in Brent 3 weeks ago, and we got the police disclosure to help us about the, you know this case, about this kidnapping. She kidnapped her child, okay? Well, in the police disclosure documents, we could see the meeting between the police officer. What can we charge you with? Nothing really. She took her own child. Oh well, okay. Well, there's no evidence, and we're going to drop everything.
It was actually because the child ran to her.
Ran to her, yeah. Yeah, the child ran to her, right? Okay, from the children's home. Okay? But they still kept her on bail to make it look good for our case, didn't it? Okay?
what is the score?
But that is an abuse of bail. Bail is to have you available for inquiries, available for questioning, and to ensure you don't abscond.
There's no charges from the beginning now, I've got my papers, I can see that.
That's right.
My children-
That to me is an abuse, because as soon as I made a decision that they weren't going to charge you with anything, she should have been released off the bail. Yeah, she should have been released off the bail.
What is the score with the social services withholding actual evidence that protects the parent, actually proves the parent innocent to the courts?
Yeah, we got one of those coming up. In fact, I've had to cancel my holiday for this because I've got one coming up next week, Thursday and Friday, where she's been allegedly spotted with the dodgy boyfriend again. So we said, well, who is it? Oh, we're not telling you. Yes, you are telling. No, we'll tell you later. That's not right. They can't say they're going to take a child off my client because they've got this person who's supposed to have seen it with this person, and I want that person in court to cross-examine. So that actually they'll be told off about the judge about this. They've got to produce the evidence.
No, they've not produced it, which protects me, if you get what I mean.
Well, there is a data protection, and also the court can order disclosure. The case of Re-R, the court can order disclosure of evidence within the... Is it in the family courts at the moment?
Yes.
Yeah, well, you can get disclosure. What we do is we serve a notice on the local authority, a complete notice of all the documents that we want them to bring to court.
They've lost it all.
Sorry?
They've lost it all.
Well,
Even though I've got the evidence, but
Right.
they've lost it all.
okay. But you can force them to disclose documents under the Data Protection Act and under the laws of disclosure and family procedures.
If you've broken the orders, if I say that.
Well,
Mr. Fleming, can I ask you another question?
certainly, yeah.
What about the other side of the coin, let's say? There's children who are reporting being abused, and I know of one case in particular where the court ordered that the child had, at a great expense was the words, had to see a psychiatrist every week until such time this child, after 2 years, would say, okay, I'll have contact with my abuser. The child lived in fear. The psychiatrist stood in court and said, in all the thousands of children I've worked with, you mentioned the word mother, and this child goes into fear and shakes and whatever, and yet they're still forcing this child now to have contact with mother.
Yeah.
Stepmother.
Yeah.
Do you come across cases like that?
Yeah,
How
yeah.
can these kids get protected?
Yeah, we do. In the early part of my legal career in family work, at the beginning of the Children Act it was, in fact, if a child didn't want to see the other person, the non-custodial person, that was pretty well it then. they wouldn't be forced to go constantly to what was called the welfare officer's office at the time. That would be it, okay? Over the past 3 or 4 years, because of the proliferation of psychologists and psychiatrists, which they are a problem to us big time, okay? More and more what the courts are doing is saying, well, let's have a psychologist. If we can't crack it, or let's have a psychiatrist, yeah? They're not just leaving it alone, they're trying to delve into it, and I don't think that's particularly helpful, to be honest. You know, after these cases, having umpteen psychologists and psychiatric reports on children.
But why force children to have contact when they've reported their parents for abuse? Now, if we as adults were abused, the police wouldn't force us to have contact with the abusers. Why are they doing it to children?
Well, every case is different, but there's two sides of the coin, right? Is the person who, against whatever the court does, whatever they order, you're not going to get to see your child, and you know, because I don't like you anymore, right? And on the other side is a child who doesn't want to see that person because of what's happened during the relationship, and you can't make yourself loved by a child at the end of the day. And so in the middle course, the court's trying to say, well, if we order the mother to do that and she disobeys it, we'll have to put her in prison, which we don't really want to do that. And if we don't give the contact, we've got a situation where she's won, and we don't want the court to be seen to be beaten, do we? So in the middle, they go for all these experts reports, umpteen reports, psychiatrists and psychiatrists. And at the end of the day, somebody has to draw a line to it at some stage or other. Yeah?
Can I ask a question? In most cases, listening to you is inspiring. If you could take on every case in the country, I could retire. But I'm getting letters all the time where the legal representation is woeful. And you said, get yourself a good solicitor. To the average person, when something like this strikes, they haven't got a clue. Have you any tips on how you can get a good solicitor?
Yeah, I sat down with 3 bottles of wine about 5 years ago, right, and I decided, how can I, because some of the solicitors I was getting, they were rubbish, okay? So I thought, I'm not taking any more solicitors on. I'm fed up of it, okay? So I've grown my own. What I do in my place now is that good people approach me, graduates, I only want young people. They approach me and they want a job. I say, okay, you come and work for me for 2 months for nothing, for a start off, but you can keep your job at Asda if you want to, right? And the chemist and the pub. They come to work for me for 2 months and we assess them if they're going to work all the hours and be committed and forget about the money. After 2 months, we take them on and we give them £7.50 an hour. And their promise from me is this. If you're good at this job after 2 years, right, I will give you a training contract, which is very difficult to get in the law. I'll give you a training contract and you've got a job at Brendan Fleming for life. Now, I have actually got, at the moment, we've got about 20, have we? We've got about 20 people, young, really good people. And the difference between my firm and other firms are 2 things. One, that every person who works for me only has a very low caseload. Most lists will be doing 30 or 40 cases, yeah? My people will have about 10 each. And one person who fought for this case, you saw the papers about Marie Black, who got a child back from France, okay? That person in my office only ever has 1 case. And if she's got that 1 case, she can't take another one on, okay? She does the getting the children, when the social workers snatch them and take them abroad, we try to keep them abroad. And that one person called Dawn, she only has 1, perhaps 2 cases. So low caseload for a starter. That person is a caseworker and stays in the office all the time. And then we have about 9 solicitors who work. So in each case there's a caseworker and a solicitor, and the solicitor does the hearings. But I have to agree with you that the quality of legal representation for parents is not of a high calibre. And the reason for that is they just haven't got the background. They take to heart too much the fact that we're all trying to work together, which we are really, work together, etc. But working together, unfortunately, does mean that you also have to make yourself a popper and put your client first and fight for your client. And all too often what happens in court, and you are experts at this, What happens in court is they all go in a big huddle in a room, yeah? And they come out with Mr. Chamberlain's paper. This is what we're doing today. It's all handwritten, it's all agreed by everybody. Oh, have a quick look at it because we're going to court. Okay, and then they go into court and it's all agreed. My staff are specifically not allowed to do that. We have our client in our room. In fact, when we went to court with these people recently, we never even spoke to the people, did we, before we went to court? Yeah? We never had a word to say to them. Why should I want to talk to them? They're out to destroy me and destroy my client's lives, right? I don't want to talk to them, okay? And when I go to court, they say, oh, Mr. Fleming hasn't been to see us, have a little meeting, a bit chit-chat. And I said, sorry, I ain't got time. I've been concentrating on my own case, to be honest. That's right. Because they only want to try and talk me into doing something for them. So we grow our own solicitors now. We've got 9 really good solicitors and another couple coming through each year. I'd obviously be able to get rid of them. I thought a few of them could go somewhere else. I could give them some work and we could work together. But also they work overnight. We have an accommodation around our office. They sleep at the office. Sometimes you go in the morning, they're in their bloody pyjamas because they've been working on a case all night. But that's what I've done. I'm growing my own solicitors. And for the first 2 months, they follow me around and they just do what I say. That they just try to get into the way that we want to work. Because we want to fight for the parents. We do not want to be pally-pally with all the other solicitors. We don't go out drinking with them. We don't go out to any law societies dues or anything like that. Because it's too serious work to be pally with the other people at the end of the day. We are respectful to them. Now we know that they've got their job and we've got our job. But also the solicitors, it's much easier representing the local authority if you want to be a solicitor doing family law. The next easy job is to represent the child, because you never really have to say anything except, yeah, I agree with everybody, just what everybody's just said, we're in court. The real hard part is representing the parents, particularly which we normally end up doing to help the other solicitor, is representing the first parent on the sheet, the first respondent, because it's the first respondent that's going to make all the arguments. Yeah. And also there used to be when I started 10,000 firms of solicitors, 10,000 firms of solicitors doing legal aid in family work. Because of the franchising and the cutbacks and the low pay and all the sort of thing that's happened, it's now down to about 2,100, and legal services want to get it down to about 1,300. And so there are a lot of solicitors who have retired of the calibre who could take on the local authority, and also some of the solicitors who sort of go on the panel, the children's panel, they then think, well, why do I work for legal aid? We're not going to have 50, 60 grand working for the local authority, pension, and they go work for the local authority. So it is difficult to find solicitors to take these cases on. We've started taking cases on in different parts of the country to help out, particularly on the non-accidental injury cases, which we've been recommended to them by different organisations. But it is difficult, it's hard work, it's very stressful work. It's so much easier to go into court and say to your client, yeah, let's agree with the local authority, let's get you an assessment, and we'll work from now on. That's dead easy, isn't it? You know, you can be in and out of court because you get a fixed fee for being in court. No matter how long you're in court, basically, you get extra a little bit longer. Rather than going into court and saying, right, I've cancelled my tennis at 9. I was going to see a few people tomorrow on Saturday, but I'm standing here all evening to fight this case for my client. I'll tell you what, you're the most unpopular person in court, but except as far as your client's concerned.
Brendan, can I just ask you, follow this up? This is very interesting, but obviously we don't want that.
Yes, we do.
How do you get around the same problem?
And you know what I do, don't you?
I very much do.
Yeah.
I have first-hand experience. But how do you get around the problem with barristers?
Yeah.
Because that's the other half of the legal battle, because I'm sure our barristers have actually fought the authority.
Well, is that camera still running? Okay. We are beginning to have an unofficial policy of not employing barristers who work for the local authority, don't we? That's what we're starting to do now. And we're telling them to their face and over the phone. If you work for the local authority, we don't think you're going to be suitable for this sort of work, to be honest. What we say to them, look, it might be the case that my client might be in court, you might have 2 or 3 cases, and she might see you working for the local authority. So we are tending, we're actually asking councils clerks, predominantly, does this barrister do parent work? And if the answer is, well, I do a bit of this, I do a bit of that, we say, no, no, no. We want somebody who does parent work. Because we know then we're going to get the heroes. We're going to get the people who are prepared to have a go.
Well, this is essential because...
we haven't cracked it, to be honest, Tim.
No, I accept that because we both know that they get into their little huddles in court, they do the negotiation, and as you say, at the end of the day, they go in before the judge and hold up a piece of paper saying, we've all agreed this, and it's between the barristers, not the solicitors, and not the parents.
Yeah. Yeah. Obviously, you know, hand on heart, we have to instruct some barristers sometime because some days we've got 17, 18 hearings to cover on some days. Normally only about 8, so we can cover between 9 of us. We are currently developing a small handful of barristers over the country, which we'll share with anybody who wants them, yeah? The one who represented us in the court appeal last week, he really had a go at everybody, okay? And he did a sort of power good. You like him, don't you, Michael? Yeah? Yeah, he's a good one, isn't he? He's off the wall. He's not in chambers. That's the other thing we're starting to do now. Find people who aren't in chambers who are on their own. But I agree with you, the number of times we've been let down by barristers, and I've had to go back on the next hearing and turn it all around again. Why is that, Tim?
Sorry?
Why is it?
It's a job for them. It's not actually anything they can relate to. If you've got personal experience, then it will hopefully bring a dimension to your profession, which actually get a different outcome. They don't have that experience.
But do you find, have you done criminal work?
No.
The calibre of barristers in criminal work is phenomenal. They're the best in the world.
I would prefer that, to be honest.
Yeah.
Because it is very adversarial,
Yeah.
as we both know.
Yeah. But when I used to do criminal work, Kenneth Clark, you know Kenneth Clark? Yeah, I used to give him loads of work. He was fantastic. The barristers in the criminal course and today, and I still go across to a little bit of crime, keep my hand in, you know, and I'm seeing, hey, he's bloody good. And you go to the family courts and you don't see it. I think a lot of solicitors go into crime because they love the advocacy, yeah? Because there's not hardly any paperwork. And like me, you can pick a folder up and run it, and you only need the guy's name, what he's charged with. You can sort everything out in the witness box. But people who want to do family work are predominantly a lot of people have got their own families. They can't commit to doing a lot of work over the evenings and weekends. They don't like court work, and so they end up putting barristers in. So when suddenly the judge says to them, right, we'll hear this now, they're not comfortable with it at all. Oh, let me have a word with my client. Let me see what we can do. So I think all the really good advocates do crime, and the less able advocates, Tim, I think, tend to gravitate towards family work, where there's so much paper, there's more paperwork in family work than there is court work, isn't there?
Brendan, you know that we obviously went to the appeal court and we had to represent ourselves because you were not able to get funding
Yes.
to represent us. And we were very, very fortunate to find a barrister who was amazing and who would speak to us at midnight.
Great.
And like your solicitors do, and it made a difference and had to take on a QC for the authority.
Yeah.
And it was like chalk and cheese.
Yeah.
The quality was very remarkable.
Yeah.
And we have him back now to help us.
And we need more people like that, and we need to tell people there needs to be a new breed.
Yes, I agree.
I'm creating them in my office. I can tell you, my people are ferocious, aren't they? Really ferocious. Okay, in court.
You know,
I'm sorry, I've gone over the time now.
please.
But don't go on.
The purpose of this meeting here is to stop forcing documents. I'm saying this for the people who sketch plans. I'm dead serious. What's happened with social services? That they've lost the original purpose.
Yeah, I agree. I agree.
And furthermore, they've misused this power. At the time that I had lived, when I was a young man, I knew of cases where 99.9 cases that the The children would go to the family. Somebody in the family had those children. There was never this confrontation. Today, there's automatic confrontation. Take the duck out. There's no mediation. There's no help for that family. It's direct. Get them in court.
Yeah.
That's how I feel.
No, I agree with you. Well, when I was doing the care work in the criminal courts, I mean, it was just normal that the social worker would go down to the house and she'd help to clear the house up, and she would clean things up, and she'd take the client down to the clinic and help her out and so forth. And it would all be, I wouldn't have a lot to do with it because the social worker was all doing. Somewhere along the line, what happened, I don't know when it happened, but I woke up one morning and found out about it, is that the social worker was the mother's social worker and the father's social worker, and they helped it all. And overnight, sometime, this person suddenly became the child's social worker. And I don't know when that happened, but suddenly, oh, it's not my problem. I'll signpost the client. I'll refer the client. Okay? I'll tell you where you could get, but I'm not taking you there. I'm not lending you my phone to make a call. Somewhere along the line, the social workers became part of the prosecution team, the witness for the prosecution, as opposed to, you know, helping them out on the ground with doing things. We
any real jobs that actually went out of this country in the early 80s, and then they decided
and the majority of social workers that I come across certainly are young, just out of university. You see their statement. I got qualified last week, and I've got this case this week. They don't have children of their own, because I'll tell you what, I've met some of these social workers after they've had a child, and they're thinking, oh God, oh, it's so different, isn't it? Oh, I've been up all night, I can't even go to work, I'm knackered. Oh my God, what? Oh, I forgot the car seat today, don't tell anybody.
Brendan, they do that because you can only get people who have no life experience to do a final job.
Yeah. Yeah.
And I enjoy it, some of them. You can see the pleasure on their faces, the way they're smiling.
It's a tick box procedure.
Yes.
You follow down the next tick box.
Yeah.
First thing is you come into the office, you switch your brain off, you switch your empathy off.
To reality.
And you follow your procedure. And at 5 o'clock you can turn it back on again. And then when you have your own kids in your own family, you need to erase from your memory what you've done to all those families in the previous 10 years. The minimum age for social workers involved in this sort of situation should be at least 30 with life experience.
Yeah.
Not 20-something.
I agree, Tim. Oh, sorry.
There should be something to it until 40, because out of the 20-something, so
yes.
in the 30s, 40s, I've just come out of university.
Particularly with adolescents. I mean, one social worker said to me, he says, oh, mother went to collect the child from school and the child didn't want to be collected from school. I says, no, he's an adolescent. He didn't want to be picked up by his mum outside at the age of 14. Sorry.
Our program was actually our contact work a few years ago when they started. And we've seen them go from being a contact worker to actually taking over our case.
Yeah.
The experience isn't there.
Yeah.
And you know another thing, sir, what I'm going to say is the lawyers, the defending lawyers, the ones who work for the council, they're not stupid. Surely they know when the case is false, and still they continue with it and prosecute it.
Now I've got my paper, you can tell that the judges corrupt, the CAF case is corrupt, social workers corrupt, police, as far as I'm concerned. Psychologists isn't corrupt.
Don't get me on psychologists. Don't get me on psychologists.
So I've got the police officer reporting abuse, and they're saying the police, I'm wrong in my training as a police officer to report abuse, and they root to my career.
Sorry.
Right, our law is already believed at the moment. Right? Not the judgment, the decision to take the kids has already been made for 9 times out of 10 years. They can tell us that. Have you ever came across it yourself, or do you believe it yourself? The decision to take a child and place them in adoption.
Even before
Yes, been there, done that, but we have evidence in black and white.
Yeah, for there's evidence. Also as well, another question. You say about the judiciary system. Is there a way whereby we can bypass that? Is there like a safe country that place people can go to before the child is born?
Right, well, the latter point, I'm going to defer to the expert. He knows more about law than me.